Good afternoon and welcome to the second part of our two-part webinar series discussing significant construction and adjudication cases of 2019. These webinars aim to cover key developments in construction and adjudication practice and how these might affect your construction project disputes in 2020. The webinar today will focus on our chosen top 5 adjudication cases of 2019. We will highlight the main facts and legal points from each and identify specific lessons to be aware of for construction contracts and claims. If you'd like to ask a question as we go through the webinar, please do so by using the Ask a Question tab. In order to keep within the time today, we'll be answering as many questions as we can at the end of the presentation rather than as we go along. If we don't manage to get to your question, or if you're listening to a recording of this webinar, we'd be happy to address any queries after the webinar by phone or email. Our contact details are noted on the next slide. So I am Lee Herd, an associate specialising in construction and engineering dispute resolution. I'm joined today by my colleague Lisa Ambrus, a solicitor in our team. Our team regularly advise on construction contract issues and disputes across a range of projects and clients. We therefore have a great deal of experience in litigation, arbitration, adjudication and mediation, where our arguments have to reflect ever-evolving judicial approaches to construction law and contracts. I'll now pass you over to Lisa, who will run through the agenda for today's webinar.
Thanks, Lee. We will start today by looking at the case of Hitachi Zosen Innova AG Limited against John Sisk and Son, which discussed whether two adjudications are the same or substantially the same for the purposes of a jurisdictional challenge. Next will be JJ Rattigan and Co. against Rosemarie Developments Limited, in which the adjudicator's decision was enforced despite an alleged failure to consider all evidence presented in the adjudication. We will then discuss Babcock Marine Clyde Limited against HS Barrier Coatings Limited, which considered whether the English courts had jurisdiction to enforce an adjudication decision where the choice of court provisions in the contract were unclear. Finally, we will look at two decisions in relation to Dèkion and Moore Limited against the trustees of the Lauren MacLeish Discretionary Trust, the first of which considered whether the dispute had crystallised, and the second which explored the concept of severability of the adjudicator's decision. Much like our previous webinar, these cases are from both the Scottish and English courts. As a reminder, much of Scots and English contract law and many of the standard form contracts used for construction projects are common on both sides of the border. The English courts have a larger number of disputes and appeals than the Scottish courts, and therefore key lessons can be learned from looking at English cases. These cases are often very persuasive in Scottish accents and vice versa. I'll now turn to our first case of today, which is Hitachi against John Sisk and Son. So this is a decision from the Technology and Construction Court, or TCC, in England, which helps to clarify the factors which are considered when determining whether two adjudications are the same or substantially the same when a party challenges jurisdiction under paragraph 9.2 of the Scheme for Construction Contracts. Hitachi employed John Sisk and Son, who we will just refer to as Sisk, to design, build and test a multi-fuel power plant at Ferrybridge in Yorkshire. Various disputes arose in connection with the contract, resulting in a grand total of 8 adjudications. The second of these adjudications considered a number of variation claims by Sisk, including one relating to acceleration works named Event 1176. Sisk's request for payment of £1 million for this event was rejected by Hitachi, as it was their position that Sisk had overpaid or had been overpaid £2.7 million for the contract. The adjudicator concluded that Sisk had been instructed to accelerate works, but valued Event 1176 at nil, on the basis that the substantiation provided by Sisk in support of the event was insufficient. In the 8th adjudication, Sisk sought payment for the works under Event 1176 and provided further substantiation in support of its claim. Hitachi challenged the jurisdiction of the adjudicator, who was the same adjudicator as was in the second adjudication, on the basis that the adjudicator had already made a decision on Event 1176 in the second adjudication. Under paragraph 9.2 of the Scheme for Construction Contracts, An adjudicator must resign where the dispute is the same or substantially the same as one that has been referred to adjudication previously. The adjudicator decided that he had jurisdiction on the basis that he had determined event 1176 was a variation in the second adjudication, but he had not made a decision on its value due to the lack of evidence provided by Sisk. He proceeded to value event 1176 at just over £800,000 and ordered Hitachi to pay Sisk. Hitachi challenged the enforcement of the decision in the TCC. Judge Stuart Smith decided that the adjudicator did have jurisdiction to determine the dispute in the 8th adjudication and rejected Hitachi's challenge. Judge Stuart Smith decided that when deciding whether or not two disputes are the same or substantially the same, the focus should be on what was decided in the first adjudication rather than purely what was referred in each. He said a comparison purely between the disputes referred to adjudication would result in a misleading and irrelevant similarity between the two disputes, and that since the adjudicator had expressly decided or expressly declined to decide the value of event 1176 in the second adjudication, the dispute in the 8th was not the same. Judge Stuart Smith further focused on the interim binding nature of adjudication, which by its nature is not designed to ensure finality from the outset. He also rejected Hitachi's argument that Sisk was using serial adjudications as an instrument of oppression, despite the fact that there were 8, and instead noted that it had simply misjudged the evidence required for the second adjudication, had gathered the necessary information, and then had come back. Therefore, a key lesson from this case is that parties can and should refer a dispute to adjudication again if the first adjudication left aspects of that dispute undecided. In this case, it was immaterial that the reason why the adjudicator left part of the dispute undecided was due to Sisk's lack of evidence in the second adjudication. Overall, it should be noted that it remains the better position to provide full substantiation and evidence for claims at the outset, as it presents the adjudicator with as much information as possible to properly evaluate the case and saves a great deal of time and expense. I'll now pass you over to Lee to discuss our second case of today, J.J. Rattigan against Rosemarie Developments.
Thank you, Lisa. This case is another noteworthy decision from the TCC. As many of you will be aware, the grounds for challenging an adjudicator's decision are limited to two very narrow grounds. Firstly, jurisdictional matters, and secondly, a breach of natural justice. This case considered whether the adjudicator's alleged failure to consider material evidence was enough to render the decision unenforceable. The challenge was framed as a breach of natural justice, with the allegation being that the adjudicator failed to deal with a potentially determinative matter. The dispute referred to adjudication related to whether or not there was a binding oral agreement on the value of the final account, encompassing all claims and counterclaims. RDL provided witness statements with both the reply and the surrejoinder, which were the second and third rounds of submissions for the referring party in the adjudication. This supported its position that there had not been a binding oral agreement. The potentially determinative matter that RDL claimed the adjudicator failed to consider was a witness statement provided with the surrejoinder, the later submission. The court rejected this challenge and granted summary judgment. In determining the issue, the TCC considered the test set out in the long-standing case of Cantillon against Vasco Limited to decide if the breach was more than peripheral, and decided in this case that the second witness statement may have been overlooked, but this was not sufficient to be a material breach of natural justice. The court also rejected RDL's submission that a pro forma paragraph in the adjudicator's decision, in which he said that he had regard to all the material before him, but had confined his explanations to the essentials, could not be taken at face value because it was a standard paragraph. As per the case of Balfour Beatty Construction Northern Limited and Modus Corvus Blackpool Limited, the fact a paragraph is a standard paragraph does not mean it's not necessarily true and accurate. The defendant in this case framed its defence around an alleged breach of natural justice. In support of this position, it referred to the Scottish case of White and Mackay against Blythe and Blythe, where the adjudicator had made an error which was so severe that it amounted to a breach of natural justice. Interestingly, the court commented that such an error was more likely to be an issue with jurisdiction, the first narrow ground, rather than natural justice. This is consistent with the approach taken in recent Scottish cases on adjudication enforcement, one of which we were involved in, where an argument that the adjudicator had failed to exhaust his jurisdiction by considering one of the respondent's key defences had success. It is possible, although perhaps unlikely, that the court may have approached this matter differently if RDL had framed its challenge as one of jurisdiction as opposed to natural justice. So what can we learn from the case? The courts remain supportive of adjudication and adjudicators' decisions as a whole, and the bar to challenge any such decision is very high. For adjudicators, this case is also a reminder to ensure you do consider all arguments and evidence provided as part of the adjudication process. A brief paragraph in your decision stating this has been done will likely be sufficient to confirm the position should your decision be challenged. For any parties in an adjudication, the case is a reminder to consider how to assist the adjudicator in presenting arguments and evidence as clearly as possible to reduce the possibility of them being overlooked, especially later in the adjudication proceedings. I'll now pass on to Lisa to look at the Babcock case.
So this was a landmark judgment from the TCC, which was reported in June of last year. Babcock engaged HSB to carry out the re-preservation of shiplift docking cradles at HM Naval Base Clyde. The contract between the parties was subject to Scots law, contained an arbitration clause, and stated that if a dispute fell within the 1996 Act, parties could refer the dispute to adjudication at any time. However, the contract did not include a choice of court clause. A later agreement between the parties regarding the contract value, which we will call the variation agreement, contained a choice of court clause, being the Courts of Scotland. Babcock referred a true value dispute to adjudication. The adjudicator decided that the gross valuation of the works at termination was around £1.5 million and directed HSB to pay to Babcock over £600,000, inclusive of VAT plus interest and fees. HSB did not pay the sum awarded and wished to challenge the validity of the decision. Babcock therefore raised proceedings in the TCC to enforce the adjudicator's decision against HSB. HSB applied to set aside service of the claim form and particulars of claim, or alternatively to stay or put on hold the proceedings based on a jurisdictional challenge, i.e. that Babcock had chosen the wrong court. HSB argued that the English courts did not have jurisdiction, or should not exercise it, because the variation agreement incorporated a choice of court clause into the contract, namely the Scottish courts, and that choice of jurisdiction should be respected. They also said the place of performance was Scotland, given the Scottish courts' special jurisdiction, and the Scottish courts were the most appropriate forum for resolution of the matter. In contrast, Babcock argued that the court should refuse a stay and should determine the adjudication enforcement application, because the choice of court clause in the variation agreement conflicted with the arbitration agreement in the contract, which has priority. They also said the choice of court clause was limited to disputes under that variation agreement. If the choice of court clause applied under the contract, it did not prevent adjudication enforcement proceedings in the English courts. And finally, the court should not interfere with Babcock's choice to sue HSB in its place of domicile in England. So what did the judge decide? He accepted HSB's position that the choice of court clause in the variation agreement sat alongside the adjudication provisions and the arbitration agreement in the main contract. It was parties' choice to have disputes dealt with by the Scottish courts, except for adjudication and arbitration. Babcock did have a right to sue HSB in its place of domicile in England. However, the judge said that the Scottish courts were more appropriate because the project and the place of performance of the contract were in Scotland. The parties chose Scots law and the Scottish courts, and the applicable adjudication procedural rules were Scottish. The court therefore granted HSB's application to stay the adjudication enforcement proceedings in England. So what can we take away from this case? This is a reminder to carefully consider the correct forum for court proceedings, whether related to adjudication or not, depending on the terms of the construction contract and any subsequent agreements or variations. It should not be assumed that proceedings to enforce an adjudicator's decision can be raised anywhere in the UK simply because the adjudication regime is governed by a statute that applies UK-wide, although it should be noted that schemes in Scotland and England are broadly the same and have very similar rules. Lee will now discuss our penultimate case to date, which is one of the judgments of the Dèkion Moor Limited against the Trustees of the Lauren MacLeish Discretionary Trust cases.
Thanks, Lisa. This first Dèkion Moor case is a Scottish case from the Court of Session, which considered whether the material parts of a contractor's claim had crystallised prior to service of a notice of adjudication. So the facts of the case are this. Dèkion Moor Limited, who are referred to as D&M, entered into a contract with the Trustees of the Lauren MacLeish Discretionary Trust, the Trust, to construct a large residential property. D&M submitted a claim for payment to the Trust in respect of interim valuation number 17. In that valuation, they sought to recover just over £2 million. Shortly thereafter, the Trust produced a final adjustment statement taking account of all sums claimed by Dèkion Moor, together with all necessary deductions for incomplete or defective works. The net amount of the final adjustment statement was just under £2 million. D&M subsequently challenged the final account adjustment statement, but the architect issued a final certificate adopting the Trust's assessment of the final contract sum. D&M served a notice of adjudication in which they claimed, among other things, claims for extension of time and reimbursement of loss and expense incurred. So D&M were successful at adjudication. Following this success, the Trust challenged enforcement of the decision on a number of grounds. One of them was that the dispute referred to adjudication by Dèkion Moor had not crystallised prior to service of the notice. It's well established in both England and Scotland that before a notice of adjudication can be served, a crystallised dispute or difference must exist between the parties. Where a notice of adjudication introduces a dispute which does not exist previously, the notice will be deemed to be premature. This was the reasoning adopted by Lord Doherty in this case, where he concluded that the claims set out in the notice of adjudication were of a different nature, order and magnitude to any pre-notice disagreement between the parties on these issues. The court identified a marked discrepancy between the extension of time and loss and expense claims that were advanced prior to the service of the notice and then those submitted to adjudication in the notice itself. Dèkion Moor had previously sought a 4-week extension of time relating to weather and 13 weeks of prolongation costs. However, in the notice, they claimed a further 16 weeks for delays relating to groundworks and an additional 30 weeks for matters relating to the building, shell and various finishes. In relation to loss and expense, previously Dèkion Moor had claimed less than £70,000, but they claimed over £200,000 in the notice. Crucially, for Dèkion Moor, Lord Doherty concluded that no dispute in anything like those terms had crystallised before the notice of adjudication was served. In reaching his decision, Lord Doherty echoed the words of Lord Justice Coulson from the TCC, who previously discouraged an over-legalistic analysis or nitpicking comparison between the dispute described in the notice and the controversy which predated the notice. At first glance, these words might lead one to assume that the disparities between the extension of time and loss and expense claims made by Dèkion Moor in Interim Valuation 17 and the notice of adjudication would be of little consequence. However, Lord Doherty thought that even when looking at the matter broadly in those wide terms, it was clear that the claims submitted to adjudication were essentially different from the ones pre-adjudication, and therefore no dispute had crystallised on these issues before the notice was served. So what should we take away from this case? While each and every case will inevitably turn on its own facts, the law is clear that a party opposing a claim must be aware of the subject matter of that claim and have the opportunity to admit, modify or reject it before any formal dispute can arise. As this case demonstrates, the court's reluctance to carry out a critical comparison between the terms of the notice of adjudication and the scope of any agreement predating that notice does not preclude them from sometimes finding that material parts of a dispute have not crystallised if the matter referred is essentially different. This case is a good reminder that the parameters of any pre-existing disagreements between the parties must be clearly documented and reviewed before referring a dispute to adjudication. In the case that simply kept on giving, Lord Doherty went on to give another noticeable decision in the Dèkion Moore case, this time considering the important question of severability. I'll pass over to Lisa to discuss this final case.
So, following on from what we've just discussed, during the adjudication, the adjudicator issued his decision on the basis that the entirety of the dispute had crystallised. Given the court's first judgment on this case, this caused a difficulty for D&M, who had been seeking to enforce the adjudicator's decision in full. D&M argued that although the court had found that parts of the dispute decided by the adjudicator had not crystallised, the adjudicator did have jurisdiction to decide the remainder of the dispute. Therefore, leaving aside the extension of time and loss and expense claims, the rest of the decision could be enforced regarding the other claims that it decided separately. D&M submitted the decision could be considered as dealing with two disputes, one that had crystallised and was capable of being enforced, and another which had not crystallised and therefore could not be enforced. The Trust argued that a single dispute had been referred to adjudication. This was consistent with the Act and the scheme, allowing a single dispute to be referred to adjudication. The Trust's position was that the whole claim was tainted due to the finding that the claim for extension of time and loss and expense had not crystallised. Therefore, the entire decision should not be enforced. Lord Doherty considered the various Scottish and English judgments relevant to severability of adjudicators' decisions, some that support this argument and some that do not. He held that Justice Aikenhead's obiter comments in Cantillon against Ervasco should be viewed as setting guiding principles rather than rigid rules for severability. It is not essential that there be more than one dispute for severability to be competent. Although the scheme for construction contracts only allows one dispute to be referred to adjudication at a time, that one dispute could, on closer analysis, be looked at as more than one dispute when it comes to determining if severance was achievable. Paragraph 21 of the scheme compels adjudicators only to decide matters and disputes that are within their jurisdiction. Lord Doherty stated that where an adjudicator's decision is partly within and partly out with jurisdiction, only the part within jurisdiction can be binding. Lord Doherty also said that to exclude the possibility of severance altogether in cases involving only a single dispute would lead to disproportionate and unjust results in a not insignificant number of cases, as success, even in relation to a small part of the decision, would extinguish the entirety of the claim. The key question for the court is whether there is a core nucleus of the decision that can be safely enforced. Lord Doherty said this was present in this case, and the extension of time award could be severed from the whole, with the remainder of the decision being safely enforced. The adjudicator's award as to expenses could not be safely enforced, as the adjudicator may have taken a different position regarding apportionment of expenses if he had reached the same result as the court. Many industry practitioners will welcome Lord Doherty's approach as being flexible and pragmatic. It is encouraging to see the court supporting the adjudication process in line with the statutory aim of adjudication decisions having an interim binding effect to the extent possible. However, the approach advocated is not without complexity. The court must now decide what constitutes the core nucleus of the decision. The language in the judgment about differing meaning of dispute is also perhaps unhelpful. Still, as Lord Doherty notes, Although the total exclusion of severance in complex cases would increase certainty, it may also lead to unjust results. Therefore, it appears that severance will continue to play a role in the court's consideration of enforceability of the adjudicator's decisions, as is a point both parties should be alive to. A final point to note on severability is that this decision follows the current trend of English case law. This is helpful, given the common statutory provisions and similar scheme provisions that apply across the UK. In conclusion, it is likely that severance will become more common in future adjudication enforcement cases, both north and south of the border. So we will now just conclude by considering the key takeaways from each of the cases that we have discussed today. The first takeaway is that it's very important to consider the forum for correct court proceedings, whether or not that's linked to adjudication enforcement. This is dependent on the terms of the contract, as well as any subsequent agreements between parties. Secondly, while it is always better for parties to provide full substantiation and evidence for their claims or defences at the outset, if there are matters left undecided in an adjudication, parties will not be prevented from referring those undecided aspects to adjudication again. Thirdly, adjudicators must ensure that they consider all arguments and evidence provided as part of the adjudication process. Parties should attempt to present their arguments in the clearest way possible in order to reduce the possibility of evidence being overlooked. Fourthly, before a dispute is referred to adjudication, parties must ensure that their positions have been set out accurately to the other party, and that it is clear to the adjudicator where they differ and to what extent. Finally, parties should be aware of the concept of severability and note that part enforcement of an adjudicator's decision is possible where other parts are determined to be out with his or her jurisdiction.
So we have now come to the end of this webinar, which we hope has been useful to you. We still have a couple of minutes to answer any questions, so if you haven't already done so, please type your question into the chat box now. While you're doing that, I'd like to take the opportunity to let you know about our construction and infrastructure breakfast seminars coming up next month. These will take place between 8 AM and 10 AM on Tuesday the 10th of March in Glasgow and Thursday the 12th of March in Edinburgh. We'd be delighted if you'd be able to join us at either of these events. If you'd like to sign up, please visit the events section of our website. So we have one question in the box today. So on the Hitachi decision, the question is that, does this decision simply allow you to revisit arguments where you were unsuccessful the first time in adjudication? As we explained earlier in the webinar, it's not that you can revisit issues correctly decided by the adjudicator. Rather, if you refer a matter to the adjudicator for decision, but he does not make a decision on that point, then that doesn't preclude you from raising the matter again. The case is clear that rather than focusing on the issue being referred in the notice, you need to focus on what actually is in the adjudicator's decision. So in the Hitachi case, the adjudicator had decided that an event was a variation, but hadn't decided the value. So the value could be revisited later, but they couldn't have revisited whether or not it was a variation. I think that's the last of our questions today, and our time is now up as we're at past. We hope you've enjoyed this webinar, which has been recorded and will be available on our website shortly. We'll also be circulating details of the recording to our participants after the webinar. So that leaves me to say thank you for listening, and we look forward to welcoming you to our breakfast